Good afternoon, good evening, good morning, everyone. Welcome to Deloitte's Debrief Tax Webcast series in Asia Pacific. Our webcast today is from our indirect tax series and is titled Export Controls, Regional Updates and How to Deal with Transfers of Intangibles. My name is Suzanne Gao, and I'm the Global Export Controls Leader based in Deloitte, Australia. I have the pleasure of hosting today's webcast. I also have two speakers with me today, my esteemed colleagues, Chen Ven Wong and Dali Zhang. Chen Ven is a tax director, and she's based in Deloitte, Singapore. Dali is a tax partner, and she's based in Deloitte, China. You may access our bios on the left side of the screen. Before I introduce the agenda for today's webcast, I'd like to take a moment to highlight some of the features of our webcast console. First, all users are on listen-only mode. If you have any content-related questions, you can submit at any time in the Q&A box to the right of your screen. Or I guess it's to the left of your screen. I'm not sure how it's appearing on yours, but it's to the left on my screen. We'll do our best to respond to your questions during the presentation. Second, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen if you want to download today's slides and related publications. Please go to the download and links box. On the other hand, mobile device users can view the slides and answer the survey on the screen. Thirdly, if you require any attendance record for this event, you will receive automatically via email with CPE certificate after watching for 50 minutes of this webcast. Okay. For those of you in this session who are not familiar with export controls essentially regulate the export and supply of military and dual-use goods and technology. Dual-use goods are goods that have both civil and potential military applications. In our experience, the requirements that export controls place on the businesses are often not known or clearly understood, and the ramifications of breaching the rules can be significant in terms of penalties and the potential impact on a nation's national security. If you go to the next slide. One more, please. As you can see on the slide with this cartoon, breaching export controls can result in significant penalties, including jail time, damage to brand, and even prohibition from selling in a particular market. So just to bring it to light and how relevant export controls is today, for example, in a speech made by the U.S. Deputy Attorney General, Lisa Monaco, in connection with the DOJ's continued efforts in investigating and prosecuting individuals for violating economic sanctions and export controls, she noted, what was once a technical area of concern for select businesses should now be at the top of every company's risk compliance chart. Export controls and sanctions are taking a more prominent place on the global scene. The geopolitical tensions tend to employ the use of export controls and sanctions even more across the globe. During this session, we will review the different updates and trends in the key export regimes and how they affect Asia Pacific in the introduction of human rights as a reason for export controls, and addressing emerging technologies and how to identify, track, and trace strategic intangible transfers. The session will close with exploring the actions companies may take to face the rising complexity of the matter. Our agenda today, which, sorry for the mix-up in the order, covers an overview of export controls in China, Southeast Asia, Australia, as well as the U.S. extraterritorial impact of export controls in the region. We will also provide an overview of leading practices in export controls compliance programs. We will then have a few minutes for questions at the end, as I mentioned, and please feel free to type any questions, as I mentioned, in the Q&A box. And we'll endeavor to respond as much as possible with the time remaining. And certainly, if we can't address the questions during this debrief, we will reach out to you and provide you feedback accordingly afterwards. So without further ado, I have the esteemed pleasure to introduce Dali Zhang from our China practice to speak about China export control regime. Dali, turning it over to you. Thank you.
Thank you, Suzanne. Hi, everyone. I'm glad to be here and share the latest development and our observation in relation to China export control. Since late 2022, the Chinese government has taken several important actions to strengthen the China export control regime. Today, I will introduce three key updates in this regard. Before we get into the detail, just to provide everyone an overview of China's legal framework on export control, especially the export control on dual-use items. Firstly, the China export control law governs the China's export control regime and set the basic rules for the controls on dual-use items, military items, and nuclear items. There are several administrative regulations and department rules that stipulates the control on general dual-use items and the specific type of dual-use items. In addition, the dual-use items list is also issued normally on an annual basis, jointly by the China MOFCOM and also China Customs. It is worthwhile to know that if we are talking about the technology control in China, other than the export control regime, China also have another set of regulation governs the import and export of technologies. Next slide. Now we come to the key updates. The first one is related to the 2023 catalog of dual-use item, subject to the import and export license requirement. This was announced in December by the China MOFCOM and China Customs. The catalog has become effective from the beginning of this year. Compared with the previous version, there are some changes that are worth to note. Firstly, there are 7 new items added to the list of items subject to the export license requirement. As you can see, 1 item is related to control chemicals and 6 items are related to high-pressure cannons. In fact, these items are not entirely new because the export license requirement was introduced for these items back to the middle of the 2022, respectively. Therefore, this addition is simply to reflect the past development on an annual basis. In addition, revisions have been made to the names and descriptions of 5 items subject to the export license requirement. These items are nuclear-related items, such as nuclear-grade graphite and also dissolvers. Lastly, to align with China's latest tariff adjustment plan, corresponding adjustments have been made to the HS codes of 16 items in the catalog, covering both export and import list. It was worthwhile to know that unlike some other jurisdictions, China so far doesn't have a classification numbering system specifically designed for export control purpose. Therefore, relevant importers or exporters are recommended to screen and review the items that they are trading against the name, description, and technical specifications set out in the catalog in order to be compliant. Next slide. The next update is around the recent announcement by China MOFCOM in further improving the export control compliance for dual-use items. This notice is a directive from the central MOFCOM to its local bureaus. It demonstrates how the China government values the importance of local law enforcement practice on the export controls. It conveys several signals to relevant parties. First, as you can see, it encouraged the local MOFCOM bureau to promote the export control knowledge to the business so as to bring up the export compliance awareness. On the other hand, it also urges the business to establish or improve internal compliance programs. Therefore, it would benefit those who have those ICP, including trade facilitation measures, such as general license mechanism. In our observation, this notice emphasizes conscientiousness and also legitimacy of the local MOFCOM bureaus when they grant the export control license. It is anticipated that the MOFCOM will carry out several regulations, inspections on the business or specific investigation. Therefore, we advise business to review their operations in China and ensure the export compliance. And it's also recommended to form a response plan in case of any regular inspection or investigation. The third update we would like to share today is about the legislation trend of China's export control regime for dual-use items. In mid-2022, China MOFCOM published a draft version of export control regulation for dual-use items and invited the public to comment. This draft introduced a series of significant changes which aim to formulate a unified administrative legislation on export control for dual-use items. Firstly, I think the dual-use item definition in China is in line with the international standards, that it covers the items that can be used for both civil and also military application. The items refers to goods, service, technology, and relevant data. Those key updates are firstly, as we introduced before, so far China do not have a export control specific coding system. But in the legislation, it has mentioned a new list of dual-use items is possible to be published that are subject to the export control in the new coding system to replace the current catalog. If so, it will be quite an important change for the China export control legislation. The current catalog is lack of coding for intangibles, which makes the catalog inconvenient to be used for items such as certain technologies or service that are subject to control. The draft regulation also expand the risk evaluation that the government will perform on their different jurisdictions. Such risk evaluation factor would include, amongst others, on national security and interests, the need to fulfill international obligation, foreign policy need, and the cooperation with China in the field of export control. The result of the risk evaluation will determine the control and will apply to item. This means that the same item destined to different country or region that have a different risk level may be subject to different controls. The draft legislation also stipulates certain reporting obligations regarding the end use and end user for controlled items. Chinese exporters, foreign importers, or third-party service providers, they are all responsible to report to the China MOFCOM on a timely manner in case of any non-compliant situations. We will discuss the licensing scheme in the next slides. The draft regulation proposed to refine the current licensing mechanism for dual-use items. In specific, for validity period, the validity period for a single license is 1 year or less, while a general license validity period will be shortened from 3 years to 2 years. There are also new measures for license exception. The draft regulation lists the scenario to which a license exception may be applied to. For example, the return of the item to its original country of export within a reasonable period of time after its entry into China. And also, there are also provisions for denied party list. The foreign importers and end users that are included in China's denied party list are generally not permitted to trade in control items. Chinese exporters can only trade with such importers and end users with special approval, but the general license and the license exception will not be applicable. In terms of supervision and legal liability, if we move to the next slides, a cross-department mechanism will be established to ensure the enforcement of export control law. This will involve key government bodies such as the MOFCOM, the Ministry of Foreign Affairs, Customs, and the Ministry of State Security. The draft regulation specifies the situation whereby a reduced punishment may be applied to a party violating the law. To conclude, the draft dual-use regulation will be another significant step of China to improve the export control regime following the export control law. Based on the proposed regulation change, it can be anticipated that there will be an increased enforcement on export control requirement by China government. Although it might still need to take time before the draft regulation to be finalized, the company are suggested to already review their business according to the prevailing regulation and also the draft available to assess the potential impact and make necessary changes to its business operations. This brings us to the polling question. Next one. Yeah. So we have this polling question that how does the China export control law and the legislation impact on your business? There are several options, including impacted, may have impact but not significant, and the company is still carrying out assessment, and not impact at all. Please select the applicable choices. As a matter of fact, we did share a similar polling question over the past 2 years, and we do see an increased number of companies which are impacted or be more aware of those changes. In addition, China Customs and China government also published a number of violation cases with penalty in their public website. Therefore, the trend is the China government, they are giving a grace period for the business to have awareness, to learn, and to make improvement on their ICP. And while we do anticipate in the next few years, it will be a more stronger action in terms of enforcement. Yeah, so let's take a look at the result. It seems that, amongst the audience, many of those are still carrying out assessment or does not have an impact, while there are around 20% of the audience indicated that there has been some impact of the China export control legislation on their business. With that, I will hand over to Sudan for Australian updates.
Thank you, Dolly. And so while many of you are sitting within the region, Australia, you may or may not be familiar with Australia export controls, but I think given some of the major programs and the multilateral agreements that have been recently put into place, I think part of you within Asia Pacific being a critical part of the supply chain, maybe this might be of interest to you. So getting into Australia export controls at this point. So with Australia, export control regime applies to the export, supply, publication, and brokering of military and dual-use items. Australia's export control regime, up until around 5 years ago, only covered the export of physical goods. But then since then, they've also included not only physical goods, but intangible transfers of certain controlled technology and information. I've included some examples on the slide of transactions or instances when the Australian export controls will apply to controlled goods and technology, and a permit may be required. They cover any export of controlled goods to be as a sale or supply, a return to the manufacturer, exporting goods for repair, an export for a demonstration or loan on a temporary basis, as well as samples or specimens sent overseas as part of research. So effectively, any export of controlled physical goods are covered. As I mentioned, the laws recently changed in the last 5 years to also include technology such as drawings in relation to controlled goods to a person outside Australia via email, or providing access to control technology stored on an electronic platform. So as you can see from this regime, it's starting to align with some of the other export control considerations, such like China, and then later on we'll discuss also the US, which also has these concepts of transfers of technology, not just hardware and physical goods. Moving on to the next slide. So I've outlined the situation where Australian export controls apply, and the question now is what goods or what technology may be controlled. And so to determine that, similar to some other regimes in the region, there are specific lists. And here we have lists, or the strategic defense and strategic good list, which is divided into two parts. Part one being military items, and part two being dual use items. I've also included a table below outlining the sections within each of those parts. And this list itself is long and tends to be quite complex. With dual use goods in particular, can sometimes not be straightforward to determine if your goods are in fact controlled, particularly when the goods are not sold with military applications in mind. The permit system for Australia export controls is administered by the Defense Export Controls Office within the Department of Defense. On their website, you will find a great deal of detail. You'll find the DSGL, the Defense and Strategic Good List itself, and an assessment tool to assist exporters with determining whether their goods are controlled or not. If there is uncertainty, it is important to note that it is possible to apply for a defense and strategic good list assessment. And this also advises in instances of uncertainty to gain certainty around what the requirements are for exporting a particular good or technology outside of Australia. One other important consideration to note is that it is possible for goods and technology not listed on the DSGL to be captured and controlled, where such goods can be used in a military or weapons of mass destruction program. So these are also captured and can be considered a catch-all control in the legislation. This is designed to cover circumstances where technology evolves quicker than the defense and strategic good list itself. Moving on to the next slide. Applications to export controlled goods or technology can take various forms depending on the type of export. In some circumstances, it's possible to obtain a general export license to remove the need to seek a permit for each and every export. The assessment considers the types of goods or technology, the end use and user, as well as considers across 5 broad categories, being regional security, international obligations, human rights, and national security and foreign policy considerations. So in summary, it's really important that businesses are aware of whether their goods and technology are controlled and are subject to the Australian export control regime. Moving on to the next slide. One that you've read a lot about and heard in the media is AUKUS. So this is a recent development. The AUKUS submarine program will be the most transformative industrial endeavor in Australian history, exceeding in any scale, complexity, and economic significance the creation of an Australian automotive since the automotive industry. Of course, it's going to have an uptick in employment for across Australia, and meaning that there's going to be also a need to be able to exchange information across borders and have Australia has a trained and experienced sovereign workforce for the arrival of the Australia's Virginia-class submarines from as soon as early as 2030. At its peak, it's estimated to be 4,000 Australian workers will be employed at any given time to design and build the infrastructure for the new submarine construction yards, and another additional 4,000 to 5,000 direct jobs that will be created to build the nuclear-powered submarines when the program reaches its peak in about 20 to 30 years. So as you can see, with this type of program and the size of the program, and also the entity, the countries that are going to be involved, and the supply chain considerations, it is going to be a lot of exchange of technical information, cross borders, the exchange of people, and the exchange of actual hardware and software. So then moving on to the next slide, I believe we do have a polling question. So will the trilateral Australian-AUKUS partnership have impact on your business? You can see we are directly impacted. The AUKUS partnership will have an impact on our business to a certain extent. We're still carrying out an assessment of the impact. The AUKUS partnership does not impact our business at all, and the other one is we don't know. While we're waiting for the results to come in, as I mentioned, given when you're thinking about a program of this size and the number of countries that are involved, besides just the Australia, UK, and US, but all the surrounding countries that may be supporting and being able to provide the talent, and also the need for the sovereign capabilities, there's going to be a lot of uptick in potential regulation. There's going to be an uptick in also collaboration amongst the various different entities, not only governments, but also private entities that are going to be contributing to the overall success of this agreement and this pact. So taking a look at some of the results that are coming in, it does seem to appear that right now it's still unknown. And that's not surprising. I think a lot of industry, and defense industry in particular, are waiting to see how they are going to play a role, not just the defense industry, but also on the technology side. So I think one of the things that we're talking about today is about emerging technology and how that's going to be captured from an export control perspective and how that's going to be shared. But it's interesting to see that also that some folks think that it may not impact their business at all. So as this program progresses, it's over a course of 30 years. It'd be interesting to see in a couple of years' time when we do this polling question again, how this might change. So I think moving on next we'll be passing the baton to Chenben to talk about Southeast Asia. Thanks, Chenben.
Hey, thanks, Suzanne. Hi, everyone. Now, when it comes to export controls, I'm talking about Southeast Asia today. So Southeast Asia is actually a mixed bag. To date, only 4 countries in the region, Malaysia, Philippines, Singapore, and Thailand, have what we recognize as a typical regime controlling the export of strategic goods, technologies, software, data, etc. Now, Singapore is the earliest adopter of strategic goods control, and it's given the number of years already. Singapore strategic goods regime is now actually quite matured. Malaysia enacted its Strategic Trade Act in 2010, so that's more than 10 years ago, with the most significant enhancement in my mind of the STA taking place in 2020. So that's about 4 years ago, when it strengthened controls on intangible technology transfers. The Philippines, although it enacted the Strategic Trade Management Act in 2015 and issued the corresponding implementing rules and regulations in 2017, the Philippines actually took an incremental approach in transitioning to the full implementation of the STMA. It only started registering businesses under the STMA in 2020 and started issuing licenses in 2021. And for Thailand, it is the latest ASEAN country to enact the Comprehensive Export Controls Law, the Trade Controls on Weapons of Mass Destruction Act, which was implemented on 1st January 2020. Now, besides these 4 countries, the other Southeast Asian countries such as Indonesia and Vietnam have still not yet enacted a comprehensive export control laws. Right. Moving on. Now, we would like to find out which export control regimes are you most concerned about in Southeast Asia, whether it's Malaysia, Philippines, Singapore, Thailand, or you don't know, or it's not, export controls is actually not applicable for you, right? As we have seen, the four countries are very different, and with the quite recent movement of into a lot of data centers, for example, technology companies moving into the Southeast Asia region or setting up shop in the Southeast Asia region, we see more and more questions regarding the control of intangible items, of technologies, of data. So for companies operating in this region, they don't just have to be worried about the data privacy and protection regulations, but now we are also very aware of the strategic controls of certain types of sensitive technology and data. So more and more we see this kind of questions, but unfortunately, this for Thailand and the Philippines, because of the early stage of implementing the export controls laws, we're not seeing too much of development in that area. But for Singapore and Malaysia, there are concerns. In fact, as I mentioned, 2020 we saw a significant development in Malaysia, in that they kind of enhanced the control regime on intangibles, as well as putting in place certain key criteria in the internal compliance program that they have put in place to assess the risk management and the export controls compliance requirements for companies situated in Malaysia. So as we can see now with the polling results, Singapore is, of course, one of your key markets of concern. It was interesting. Thailand is actually quite important for a lot of companies when it comes to strategic goods as well. But as I mentioned, later on we'll go slightly more in depth into what's happening in Thailand. But that's good to know, right? Next slide, please. Now, there are definite similarities and differences between the export control regimes of Malaysia, Philippines, Singapore, and Thailand. One major commonality is that all of the four countries' dual-use lists are actually based on the EU's dual-use list. However, there's a very significant difference in that the four countries actually adopt the EU list at different times because of their internal legislative processes. Now, for example, Singapore implemented the EU's 2021 dual-use list in October 22. That's last year. So Singapore's current dual-use list is based on the EU's 2021 list. However, if we look at Malaysia's latest dual-use list, which was updated in 2021, it's actually still based on the EU's 2019 dual-use list. So companies which operate in multiple ASEAN jurisdictions need to be mindful, of the different timelines of the amendment of the control list in the different countries. So again, to remind our audience out there, for example, if you operate in Singapore and Malaysia, the control lists are actually different. So what may be controlled or not controlled in Malaysia, what may be controlled in Malaysia may not necessarily be controlled in Singapore at the same time because of this difference in adoption of the EU control list. So we should be mindful of especially of this, because it may not apply across board to all four jurisdictions. Right. Next list, please. Next slide, please. Sorry. Yes. Now let us take a look at the latest export control developments in the four countries. Right. Now Singapore, as I mentioned, updated our dual-use list in 2022, which is based on the EU's 2021 dual-use list. And also, we specifically put in place controls in respect to Russia and Myanmar. So we have to be very careful, especially businesses who, in this part of the world, we tend to do quite a fair bit of business in the region as well as across region. You should be mindful that Singapore has put in place specific controls for Russia and for Myanmar. And then if you can see on the slides, on the slide itself, there are several, Singapore has also made several changes or amendments to different requirements for on-export controls. You can go through it yourself. Now for Malaysia is interesting. It tightened its oversight, mandating the delivery, maintain the submission of the delivery statements and pre-registration of signatories of end-use statements. So in other words, if you are exporting strategic goods from Malaysia, you need to, so prior to applying for a permit, you need to first register the whoever that is signing the end-use statements, which is from the importing side. So this is something that you have to be mindful about. Now, on the other hand, besides the tightening of oversight, Malaysia has also made some provisions on relating to violations of export control law. If we remember, Malaysia started out by putting in place capital punishment on violations of strategic goods control. So now what Malaysia has done is now it has provided for compounding of certain offenses, particularly focusing on unintentional mistakes. So if you make a mistake and you forgot or you make certain mistakes and that are unintentional, so not fraudulent activities or not malicious. So there is a way now for the Malaysian government for businesses to go in and for compounding of certain offenses for unintentional mistakes that happen. So this is quite a big step in encouraging companies to be more aware of and more upfront about their export controls related activities. Moving on to the next slide. Now, the Philippines has just started enforcing the STMA on 1st January 2023 this year. So what this means is that, remember, we were talking about how it started registering business, started issuing licenses and permits last year. But this year, on the 1st of January 2023, any export of strategic goods without STMO authorization will no longer be allowed, which means they've started enforcing it already, started enforcing the law already. So the Philippines have also issued notifications on specific movements of strategic goods, such as the export for repair, maintenance, replacement, as well as the return after repair. So these are more these are notifications that target specific types of activities and provides advice and guidance to companies on what to do in this type of situations. Now, for Thailand released its dual-use list, which is based on the EU's 2019 dual-use list. Now, so remember what I said earlier, Singapore's is based on the EU's 2020 list, and Malaysia is on 2019 list, and now Thailand is also still based on the 2019 list. So Thailand has identified 6 core elements for internal compliance program, now upon which exporters will be assessed. I have listed the 6 key elements of ICP on the slide. But what we understand by by talking to the authorities is we understand that because Thailand is at the very early stage of implementing and its export controls regulations. So we understand from the authorities that, if you have existing ICP program that you use enterprise-wide, for example, and, because your headquarters and all applies the ICP to the entities in Thailand, if these entities in Thailand already has existing ICPs, the Thai authorities, we understand, will assess these type of ICPs quite favorably, actually. So for companies that are based in Thailand, and if you have existing ICPs that are enterprise-wide, now is actually a pretty good time to get your ICP assessment done, because the Thai authorities will view such type of enterprise-wide ICP programs quite favorably. So this is a good time to go in and speak with the authorities. Okay, moving on to the next slide. Now, besides, the domestic export controls regimes, we know that, Southeast Asia, South Asia is actually the most heavily sanctioned region in the world. And Southeast Asia, because of our close economic ties with China, Hong Kong, Myanmar, and we do have North Korea as a neighbor, our companies are very mindful about what's happening in the region, as well as in the broader international developments. So besides local export control requirements, companies operating in the Southeast Asia regime, we must also be very careful in navigating through the US export controls and sanctions, the EU requirements, and as well as China's export controls and sanctions. We're all very mindful of the developments in the world that will have enormous impact on our business in Southeast Asia. So I would like to put it to my two esteemed colleagues. Dolly, you had earlier spoken on China's export controls. Now, what do you see? What are the implications for Southeast Asia businesses? What should they do?
Yeah, sure. So because Southeast Asia has becoming a very major trading partner of China, I think for those who are trading with China should be aware of China's export control law, in particular the end use and end user control, as well as the control item, so that it can properly structure its supply chain and business plan. Thank you.
Right, thanks, Dolly, and of course for Suzanne. Now, you're going to follow up after my section to talk about U.S. regulations. But why should businesses out here care about U.S. regulations, especially those who do not do business with the U.S.?
All right. So this is a very poignant topic, and I think as I'll get into a little bit more of the weeds in the next portion of our presentation, but unfortunately or fortunately, the way it works is this slide shows is that the U.S. regulations are extraterritorial. So while you may not be doing business in the United States, what the technology that you might be incorporating or what your technology may be based on may have a U.S. nexus. And that's the thing that when you're thinking about tracing the origins of what you're receiving and incorporating into your own product, knowing where they're coming from and whether it's U.S. technology or not may really impact whether these regulations apply. And even when it comes to sanctions, if you're thinking about, you may think that there's no U.S. nexus, but if you're doing business through certain financial institutions that might be sanctioned by the U.S., or if you're transacting business in U.S. dollars, that might actually be enough to cause concern. So there's a lot of different touch points that normally, if you're solely operating within the region of Asia Pacific or Southeast Asia, you might not think so. But because of the globalization of the supply chain, there's a lot of different avenues in which U.S. content, US technology, US hardware, and may infiltrate or trickle into your business. And in that sense, because of the fact that the US laws are extraterritorial, that's where it becomes quite sticky and that you need to pay attention. So I think with that, Chinven, thanks so much for that, and Dalian. So we're moving on now to this portion of the US. And so all of you are sitting within Asia Pacific, and this is an Asia Pacific debrief. And so you may be wondering why we're covering the US regulations. But as I mentioned just before with Chinven teed it up quite nicely for me, is that there is the extraterritorial impact of the regulations. And so for those of you that might not be familiar, these are the three key ones that we're going to talk about today. Is that there's the U.S. Department of Treasury and the Office of Foreign Assets Control, which administers the regulations that deal with sanctions and embargoes. And then the second one that you're probably more familiar with is the U.S. Department of Commerce, Bureau of Industry and Security, that administers the Export Administration Regulations, which deal with the dual use and military items. And then the U.S. Department of State, which is under the Directorate of Defense Trade Controls, is administers the International Traffic in Arms Regulations, and which is called nicknamed the ITAR, which I think for those of you that are more involved in the military arena, that's where you'll probably be even more concerned because of the impact of those regulations that deal with military items. So the ITAR and ENR and OFAC are extraterritorial, as I mentioned. And so they look at the item, not just the origin, but where it may end up. And the regulations follow the item. So that is something where we'll get into a little bit more in the next slide. So as with other jurisdictional regimes that we discussed today, the U.S. export control laws and regulations capture hardware, software, data, and even some services. And like other regulations, the ITAR, the EAR have lists, which is under the ITAR, it's the U.S. munitions list, and under the EAR, it's the commodity controls list. Those are the items that are defined that are going to be considered controlled, but just like how Australia has a catch-all and China has a catch-all, there are catch-all provisions in each of these regulations that should the government determine that is sensitive or is something that they would like to control, there is a mechanism for them to do that. Because of the fact that these are extraterritorial, it's critical for companies to understand what their products are, how they were made, where they're going, and with whom they're going to be shared. These pieces of information are necessary to understand whether the items are subject to the U.S. export regulations and under which jurisdiction, meaning whether it's under Commerce or State Department. What makes these regulations quite onerous is the fact that they are extraterritorial. And so and also they apply not just to U.S. persons, and persons meaning actual physical people, but also businesses and entities, but also to non-U.S. Made commodities and that incorporate export controlled items, software, technology, and also non-U.S. made items that are the direct product of U.S. technology. So if you're thinking about some of your businesses that may be doing collaboration or joint ventures, or joint research and development with your engineering teams, you have to start to consider as to whether or not the U.S. regulations might apply. Moving on to the next one. These three sets of regulations apply not just on U.S. entities, as I said, but also non-U.S. entities. And because the regulations follow the item and the service, as well as the data across borders, they apply to exports, re-exports, transshipments, and also deemed exports. And I think one of the more complicated aspects of the deemed export is that from a U.S. perspective is that, for example, if a Canadian person who is situated in the United States receives, let's say, ITAR, which is the State Department, the military item, without prior authorization, that is the receipt of that controlled information to the Canadian within country is still considered an export to Canada, even though that individual is physically situated in the United States. So that's that whole concept of deemed exports. So that there's a lot of ways in which the U.S. regulations can capture and can be triggered with the export control regimes. Moving on to the next slide. Reviewing a particular export transaction, whether it is subject to U.S. export controls, laws and regulations, may require prior authorization from the U.S. government in order to conduct the transaction. And here we have re-export and retransfers and re-export approvals, because we're starting from the viewpoint that the item is already in your country in Asia Pacific. So let's assume that you received the item properly under some sort of authorization or some sort of exemption or exception, so that in order for you to then retransfer or re-export those particular items, you actually may need to go back to the U.S. government to get authorization. So again, there's an aspect of governance and compliance that you might want to invest in to make sure that you have policies and protocols in order to address these types of concerns. And certainly there are, as I mentioned, exemptions and exceptions, and just to touch lightly on that, what that means is that within each of the regulations, there are provisions that allow for you to receive controlled items, whether it's under the ITAR or under the EAR, should you meet certain requirements or certain specifications. Then you don't have to go to the U.S. agency to get an approval. Or in most situations, your U.S. partner does not need to go to the State Department or the Commerce Department to get a license. Instead, they can invoke an exception or an exemption in order to send the item to you in Asia Pacific. But again, the regulations are quite detailed, and they do identify when a re-export authorization or a re-transfer authorization may be needed. So you'll just want to make sure that you work with your compliance leads to make sure that you do that analysis to see if that's needed. Okay, moving on to the next slide. So I gave you a very high level of setting the tone around the extraterritoriality of this, and why it really matters is because the regulators in the United States actually have the ability through their regulations to fine anyone who's in violation of these regulations. So the fines can be quite extreme, into the hundreds of millions of dollars. And as just like some of the other jurisdictions that we discussed today in Southeast Asia, as well as in China, there is also criminal penalties, which may involve imprisonment, or in Southeast Asia, quite capital punishment. So they can, for purposeful violations of the laws. The other thing that is really quite tricky is because of the fact that there is a track record of the U.S. government fining non-U.S. companies, that there is not only the fines and penalties involved, but also the reputational aspects of it, because of the fact that both of these agencies, the Commerce Department and the State Department, they do publish on their websites the companies that have been fined, and a brief description of why they were fined. And so this, given that that's publicly available for people to peruse, and oftentimes, depending on the size of the penalty, they may be actually put into publications like, local, like newspapers and media, that creates a brand risk to you. On top of that, and then you can see how there's a domino effect of that, is that, with the reputational risk, that may impact your business, it may impact your ability to conduct exports or other transactions. The U.S. government does have the ability to debar you from contracting in the extreme cases. And in addition, there's oftentimes, for the more egregious cases, the U.S. government might impose not just fines and penalties, but also remedial measures, which include augmenting resources. You may say that you might need to hire more people to deal with trade compliance, or you might need to implement IT systems, or automated solutions such as GTS or GTM, that for those of you that are familiar with those types of trade modules. And so those all have a cost behind it, and then including having to conduct third-party audits of your compliance program. So when China and Southeast Asian countries are looking at ICPs, that's one of the things that they're going to be auditing. So, and in the case that you might get something wrong and be subject to these types of audits, they'll be examining that as well. So there's something to consider. Okay, moving on. We're running a bit out of time. So again, this is just to consider the U.S. nexus piece. Is there a U.S. person, U.S. financial institution, U.S. origin, and so forth? And I think we've sort of touched upon those in some of the other examples that we discussed and with Chen-Ben. Moving on to the next slide. So just to give some recent updates, just really, really quickly, in June, the Commerce Department announced 4 policy changes. The first 2 changes are significantly higher penalties and non-monetary resolutions for less serious violations. BIS has also eliminated the no admit, no deny settlements where companies agree to pay a reduced penalty for entering into a settlement. The company will still be required to admit that the underlying conduct occurred. And then the fourth one is the process of voluntary self-disclosures, which refer to the company's self-reporting of potential violations of U.S. export control to BIS, have also been revised. In July, there is also, which was probably more significant, is that in very novel, more recent developments, that the DDTC, the State Department, issued 2 new temporary licenses, the Open General License number 1 and Open General License number 2, to permit the transfer of retransfer certain articles between Australia, UK, and Canada. Actually, as of today, they just issued an update that they are adding more items to those Open General Licenses for 1 and 2, and that'll be effective May, I think, 12th, 2023, so just in a few weeks. In October, another big thing is that incredibly important is that new export controls were placed on advanced some supercomputers and semiconductor manufacturing items. And of course, thinking about the purpose of export controls of regional stabilities, foreign policy, national security, the U.S. took a position that in order to execute on those things, that they these restrictions targeted manufacturing of these items within China. So basically, a new set of export controls limits China's ability to get these various different advanced computing chips and develop supercomputers and manufacture advanced semiconductors, which has had a significant impact in the region. Another development in December, the State Department also issued a proposed rule that would treat 2 additional types of transactions that are not export or re-export retransfers. This would mean that these activities would not require authorization under the ITAR. In February, moving to the next slide, another development on OFAC and BIS have broadened their controls and aimed towards Russia. Obviously, given the war with Ukraine, the U.S. has used these sanctions as a tool to help with respect to that. In February, there's just to give you an example of that, from a penalization perspective, that there was an order imposing a fine of close to $3 million on a company, 3D Systems. And it was also required to retain a third-party consultant to complete 2 audits. So this is just another example of those types of enforcement activities that can occur. Okay, moving on to the next slide. So we probably, just given the interest of time, we may want to skip this polling question and just go on to talking about the Global Trade Compliance Program. So each of us, and I'd welcome back Dolly and Chen-Ben to this discussion, is that each of the various different parts of Asia Pacific and the regulations to have the ICP concept and requirements of having an ICP in place. And so when you're looking at multinational companies, we're looking at how do you do that when you're considering a variety of different regulations. But I think at the core, all compliance programs do have these key 3 elements of people, process, technology. So, you're looking at a global trade organization and who's going to own the risk. How do you design the program? What are the procedures in place so that people can follow and repeat as, people move throughout the different organizations? And then also the technology side of tools. So I briefly touched upon GTS and GTM and other sort of classification tools that may be out there to help you track and help automate some of this so that you can leverage your people in a more strategic way to carry out the global trade compliance elements. So on this slide, you'll see sort of the key highlights of the structure of a compliance program. And I don't know if Dolly or Chenben, if you just want to add in from your country's perspective and regional perspective as to how it might differ or how similar it all is in respect to the fundamentals of the ICP.
From China perspective, I can see there are a lot in common because China produced 9 key elements for ICP, which can be easily correlating to the US one. And therefore, I think it's essential to have one set of globally or regionally aligned ICP while taking into consideration some local specifics. Thank you, Suzanne.
Great, thank you.
Yeah.
Chenben, anything else?
Yeah, I agree with what Dolly said. Having a global or enterprise-wide ICP program is essential because that will kind of, make it more common throughout the whole company. But at the same time, it has to be mindful of local requirements. Like I said, not just in terms of the list, especially in Southeast Asia, where we have so many countries, so many different regimes, and the control lists are different. But at the same time, also, for example, the Philippines has a similar deemed export requirement as compared to Singapore, Malaysia, and Thailand, where there's no the concept of deemed export or re-export may not necessarily be the same. So I think besides having a global ICP program, we must also be mindful of the local requirements as well, and the ICP needs to take care of that.
Great. Thank you, Chenben and Dolly. Moving on to the next slide. I think this really, captures in a snapshot sort of the way we would structure a compliance program. And so, thinking about a risk assessment and the design of the actual program, and then also the tone from the top, I think is always critical. So, regulators always want to see that from the very top of the organization all the way down to the grassroots of the organization understand their role in trade compliance and export controls and being able to execute a program. I think as Dolly and Chenben both mentioned, I think, and maybe perhaps it might be captured on the next slide. There's things that you need to consider for companies is just the information that's being maintained, how accurate is it, making sure you know who your parties are, and then just understanding all the different transactions. But I think really moving on to the next slide is what Chenben was actually referring to, is looking at when you're looking at a global program and you're looking at multiple countries, certainly a lot of the companies in China have a massive footprint across the world. So you're thinking, okay, even though it's headquartered in China, you need to think about all the other possible entities that might be involved in your overall structure, and then thinking about just how do you have a program that actually can resonate amongst all your people. So making sure that it does address the various different regulations that might apply. So thinking about U.S. companies that have a footprint in Asia Pacific, they have to align not just the U.S. requirements, but also the other regional requirements. And then also just the ability to understand what the program is. And so I think one of the key things is that we see in Asia Pacific is making sure that the people that are actually using these are day-to-day can read it. I mean, it's as simple as that. It's like making sure that it's in the local language. Oftentimes we sort of forget that that's something that straightforward. It can make a huge difference. And certainly, there are some things to consider about the cultural differences. So from one country to another, how things are addressed and how things, from an audit perspective, so the idea of like having to be very transparent about what's going on to your internal audit team and making sure that those communications are well paved to understanding that the overall purpose of these types of activities within a company are for the overall benefit of the company. So it's not an I got you kind of moment and getting a bad grade. It's about how do you continually improve your program and continue to grow the organization in a compliant manner. So I think with that, I know we've run a bit over time, so we really appreciate all of you staying on. I know there was a few questions that came in. I don't know if Dolly or Chenben, you want to adjust those quickly, or if you want to take them offline. I leave it up to you to make that decision.
Yeah, I think there are several questions. We may get back to those who raised the question separately via email.
Okay. So with that, we just want to thank everyone for joining today's webcast. As I said, this if you need CPE, you should be able to get that certificate. And please join us for our next one. I don't have the specific date of when that is, but I'm sure you'll be getting an invite shortly for that. And certainly you have our contact information. You can download the presentation, which also contains our contact information. So if you have any specific questions or any follow-up, we welcome you to reach out. So thank you very much and have a wonderful evening, have a wonderful day, have a wonderful afternoon.